I've worn this robe for 37 years, long enough to understand that justice isn't simply about surveys and deeds and the precise language of property law. It's about whether this room operates the same way regardless of who is standing in it. It's about what a line on a map actually means when the person who crossed it has spent 23 years in rooms that rearrange themselves around her. And on a still Tuesday morning in Virginia, a property case landed on my docket that looked on its face like a boundary dispute and a misplaced fence. What it actually was, I understood the moment Vivian Hargrove walked through the door, was a question this bench gets asked more often than people realize. Will you do for this woman what you would do for anyone else? The answer, as it always is in this room, was yes. Vivian Hargrove arrived with 3 attorneys, not one as would be standard for a civil property matter of this scale. 3 from a firm whose website lists, among its areas of practice, the representation of military families and federal contractors. The lead attorney, a polished man named Douglas Wren, carried a briefcase and the specific bearing of someone who has spent his career being the most prepared person in county courtrooms. The 2 associates arranged themselves slightly behind him. Vivian herself walked through the courtroom the way certain people walk through spaces they consider beneath them but are temporarily required to occupy. Not contempt exactly, but the composed distance of someone for whom this is a minor errand. The cream blazer was tailored, the pearls were real, her hair and makeup were composed with the specific effort of someone who has learned to present herself as though effortlessness is a natural condition. She carried a structured leather bag. She found her seat. She did not look at the plaintiff. Cecilia Warren was already seated when Vivian entered. 68 years old, cotton blouse, a cardigan that had been washed many times. She held a manila folder in both hands, the way you hold something that cannot be replaced. She watched Vivian enter with the expression of someone who has spent 6 months waiting for a room to take her seriously and is not yet certain this one will. Before I called the proceedings to order, Douglas Wren rose to address the court. He informed me that General Hargrove had been briefed and was available by phone should the court wish to speak with him. He noted that the general had significant relationships within the state's judicial community. He described the matter as a contractor misunderstanding and suggested that mediation would serve everyone more efficiently than a full hearing. I let him finish. Then I asked Priya Anand to present the complaint. Priya Anand presented her case the way I have learned to recognize good legal work without performance, without inflation, letting the documentation carry the weight. The survey, the original deed, the certified land assessment from a licensed surveyor retained by Cecilia's attorney, and then the county's own surveyor's letter confirming the encroachment at exactly 18.3 feet. She presented the photographic record, 34 years of images documenting the orchard at the eastern edge of Cecilia's property, the trees visible and identifiable across every season and decade. She presented the letter from the landscaping contractor's project manager, obtained independently, acknowledging that the fencing had been installed according to specifications provided by the clients, specifications that did not match the legal property line. She noted that the county had received Cecilia's formal complaint and had allowed it to sit without action for 6 months. Douglas Wren rose immediately. The contractor had acted in good faith. The error was inadvertent. The Hargrove family had invested significantly in the property, and the appropriate remedy was nursery replacement value for the 3 trees. He provided a figure. It was 1/10 of what Cecilia Warren's documentation suggested, and it contained no reference to the history those trees represented. I looked at Cecilia. I asked her to describe the trees to the court, not their variety, their history. She described the first one, planted by her husband Arthur in the spring of 1990, the year after their wedding. The soil turned by hand 3 times because he wanted it right. The second, a honeycrisp planted when their daughter was born because at age 4, their daughter had decided that honeycrisp sounded like a perfect thing. The third, planted the year Arthur retired because he said he wanted something that would outlast the years he'd given away. Her voice did not break. Vivian adjusted her pearls. I saw both of these things. I looked at Vivian Hargrove and asked her directly whether she understood that the fencing her contractor had installed was on Cecilia Warren's legal property. She responded with the measured, practiced tone of someone who has navigated uncomfortable social situations for 23 years by deploying the weight of her position. She said she was sorry if Ms. Warren felt that way, but that her husband's service to this country entitled their family to some degree of consideration. She said the disruption this proceeding was causing to a military family preparing for a deployment cycle was itself a form of harm that the court should weigh. She said she had supported her husband's career through considerable personal sacrifice and would appreciate the court's understanding. I removed my glasses. I set them on the bench in front of me. I said, "Mrs. Hargrove, General Hargrove's service is noted and respected by this court. It is not before this court. What is before this court is a survey, a deed, and 18.3 feet of Ms. Warren's property that currently has your fence on it. I want to ask you whether you understand those two things to be separate." Douglas Wren began to rise. I raised one hand without looking at him. I asked Mrs. Hargrove. Her composure shifted, not breaking but bending, clear's throat, in the specific way of someone who has not previously encountered a room that makes that distinction. She looked at me for a moment. Then she said the court should call the general. He would clarify everything. I looked at her for a long moment. I said, "Mrs. Hargrove, if you are telling me that General Hargrove has knowledge of this encroachment and authorized it, I would be very interested in speaking with him on the record." The room went quiet in a particular way. Douglas Wren sat very still. It was the stillness of an attorney who has just understood that his client has handed the court something it did not have before. I asked Cecilia to continue. She opened the manila folder. The photographs were organized chronologically. The first image was from 1989, Arthur in work clothes kneeling in turned soil, pressing a root ball into ground he had prepared himself. The photographs move forward through the years with a specific accumulation of a life lived consistently in one place. The trees in spring, in summer, in the particular gold of October. Cecilia and a young woman who became her daughter. Then a daughter with small children. Then those children older reaching up into branches. And then the last photograph, the morning she went outside and found the fence where the orchard corner used to be. I reviewed each one in silence. Then I looked up at Vivian and asked whether she had seen these photographs before. She said she had not been aware of the sentimental significance. I said quietly, 34 years of photographs does not require your awareness to constitute significance, Mrs. Hargrove. I asked Priya for the county's complaint response timeline. The formal complaint had been filed with the county's zoning office. It had been acknowledged, and then for 6 months it had sat. The county's own surveyor had confirmed the encroachment. The complaint had still sat. I noted it in the record. The referral was already forming in my mind. Douglas Wren had walked back his client's suggestion about the general's personal involvement, but the record was incomplete in a specific way. Since the moment Douglas Wren rose before the proceedings began to mention the general's availability and his relationships within the state's judicial community, I had been thinking about a question only the general could answer. I directed the clerk to place the call on speaker. The general answered on the second ring. His voice was brisk, assured, the voice of a man who has spent a career being the most authoritative person in whatever room he occupies. He thanked the court for its service. He described the situation as a contractor error that his office intended to address. He said his family had nothing but respect for their neighbors in Stafford County. He was confident the matter could be resolved to everyone's satisfaction. I let him finish. Then I said, "General Hargrove, I appreciate your time. I have one question. Were you aware before today's proceedings that the fencing installed on your property extended 18.3 feet past the legal boundary onto your neighbor's property and that the installation resulted in the removal of trees she has documented for 34 years? A pause, not a brief pause. The kind of pause that is itself an answer before the words arrive to confirm it. The general said he was aware there was a boundary matter pending. I said, "A boundary matter pending? The trees, General, were you aware of the trees?" A longer pause. When his voice returned, the brisk assurance had gone somewhere. I was aware fencing work had been completed. I said, "Thank you, General. That is what this court needed to know." I set the phone down. I looked at Vivian Hargrove. She was looking at the table in front of her, not at the phone, not at Cecilia, at the table with the expression of someone who has just understood that the resource she had been certain would resolve this morning has instead documented something the court needed documented. Douglas Wren was on his feet. He said the general's statement confirmed the inadvertent nature of the error. His client was prepared to offer full replacement value at current nursery rates plus installation. I said, "Counsel, nursery replacement value does not account for 34 years of documented history. It does not account for the fact that 2 of those trees were planted by a man who is no longer alive to plant new ones. This court is not interested in nursery rates. This court is interested in what is owed." I turned to the matter of the county. A formal complaint documenting an 18.3 FT encroachment confirmed by the county's own surveyor had been filed and had sat without action for 6 months. This court intended to refer that matter to the county supervisor's office with a formal request for review of the zoning department's complaint handling procedures, accompanied by the full case record, including the non-response timeline. The ruling was this: the fencing was to be removed and the property line restored to its legal boundary within 30 days at the Hargroves' expense by a contractor approved by Cecilia Warren's attorney. The damages for the 3 removed trees were not to be calculated at nursery replacement value. They were to be calculated by a court-appointed assessor whose methodology would account for the documented age of the specimens, their historical significance as established by 34 years of photographic record, and the irreplaceable nature of trees planted by a specific person in specific soil for specific reasons across a 34-year marriage. The assessor's figure would be reviewed and finalized at a compliance hearing in 6 weeks. The county zoning department complaint handling procedures were referred for formal review, and I noted formally for the record that General Hargrove's rank and service record were honored by this court and were in no way implicated in this ruling, which was a property ruling about a fence on the wrong side of a line by 18.3 or fair. Douglas Wren began to speak. I raised one hand. I am not finished, counsel. I looked at Vivian. She was watching me now without the practiced composure, without the managed distance, simply watching and waiting, and for the first time, not certain what came next. I spoke directly to her. Mrs. Hargrove, your husband's service is real. It deserves respect. I want to be precise about what that means and what it does not mean. Respect is not the same thing as exemption. This country's military defends the rule of law. That rule of law includes property boundaries. It includes the right of a 68-year-old retired schoolteacher to have the trees her husband planted by hand remain on her legal property. What you ask this court to do today, call the general, allow his rank to enter this room and rearrange what the survey says, is not a request that honors his service. It is the opposite of what his service is for. Vivian looked at the bench. She was not managing the room anymore. She was being addressed by it, possibly for the first time in a very long time, as herself and not as a title. She said nothing. I called Cecilia Warren forward one final time. I told her, the trees that are gone cannot be restored by this court. What this court can do is ensure that what remains on her legal property is protected, that what was taken is compensated at a figure that reflects its actual worth, and that the process that failed to protect her for 6 months is reviewed and corrected. Cecilia looked at me and said quietly, Arthur always said the law was for everyone. I just needed to find a room that believed that. I kept that sentence. I keep it still. The fencing was removed within the 30-day window. The court-appointed assessor arrived at a figure of $47,000 for the 3 removed trees. Douglas Wren filed a motion to reduce it. I denied the motion. The Hargroves paid. The county zoning department's complaint handling review produced a new protocol, formal written response required to all documented encroachment complaints within 30 days of filing. The protocol was named informally among the zoning staff who implemented it for the case that produced it. Brannon received 4 new referrals from property owners in Stafford County within 6 weeks of the ruling. She took all of them. Cecilia planted 2 new apple trees at the edge of the restored property line in the same soil where the originals had stood. She did not name them. She knows what they are. After the room cleared that Tuesday, I stayed in my seat for a few minutes. I noticed that Cecilia had gathered her things carefully, but had left the manila folder on the evidence table. A corner of one photograph was visible, the edge of an orchard in summer light, branches heavy with fruit, a hand reaching up. That is the whole of it. I want to say something directly to everyone watching this. This story is not about the military. It is not about one family's sense of entitlement or a fence installed 18 FT in the wrong direction. It is about something older and considerably simpler, whether the room that is supposed to apply the law equally actually does. When the person asking for an exception has spent 23 years in rooms that rearrange themselves around her. Cecilia Warren did not come to this courthouse expecting anything. She came because a survey said 18.3 FT, and she had 34 years of photographs and a husband who told her consistently, and until he was no longer there to say it, that the law was for everyone. She decided to believe that. She hired an attorney who prepared a case that could not be disputed, and she held a manila folder in both hands and waited for a room that would read what was in it. Vivian Hargrove came believing that a phone call to a general would resolve the matter. The phone call was made. It did not resolve it. It confirmed what the survey already said, and it confirmed it on the record. What this bench is for is not complicated. A property line is a property line. A tree planted by a man who is gone cannot be replaced at nursery rates. And rank, real rank, the kind that was earned, and that means something, does not ask courtrooms to make exceptions. It respects the law because the law is what it defends. Arthur understood that. He was right. Share this. Subscribe. Justice still has a pulse. It belongs to everyone who walks through that door with the documentation and the patience to wait for a room that will read it.